Meanwhile, the point-of-sale operators in Abuja have expressed mixed reactions to the Supreme Court ruling, suspending the February 10 deadline date for the old NAIRA. Noel Sampson speaks to some of them.
Most operators are taking advantage of the NAIRA scarcity to increase their charges as people struggle to get money before expiration of deadline for the old NAIRA. But the Supreme Court ruling on Wednesday restraining the CBN and commercial banks on the old NAIRA deadline has changed all that.
Yeah, I'm in support of it, so that the new NAIRA note will go around, so that everybody will have it. Then the situation, how things people are angry and everything will now calm down. So I'm in support of extending the time.
Some of the POS operators are not happy with the court ruling, saying the February 10th deadline should not be shifted.
In my own idea, it's not a good idea because it is supposed to have a definite date. With that, Nigerians can plan towards that date. Now that they have shifted it indefinitely, now it makes Nigeria to go through more suffering. Because that old NAIRA, we have hope that in the next few days now, old NAIRA will go off. Now we'll be using the new one. That if you go to the bank, at least you can get new one. Now, if you go to the bank, you cannot get old one. New one is not there. So now cancelling it is not good for us. It's not good for the old Nigerians.
So I think they shouldn't cancel that deadline they give. Like me, even in the first place, because why people are holding the new currency is because of the fact that the old currency is still in the market. If the old currency is not in the market, I think the new currency should be in circulation.
The old NAIRA will now remain legal tender pending final determination of the suit before the Supreme Court. It may take some time, but it's a huge relief for many. Noel Sampson, Trust TV News, Abuja.
That's it. A senior advocate of Nigeria, Sam Kabu, joins us to interpret the ex parte motion granted by the Supreme Court. It's a pleasure to have you join us this morning.
Thank you very much.
I've read so much from your people that at some point I am not even sure what I'm reading. After the Supreme Court's pronouncement, I was reading a legal opinion by the CBN lawyers, and they were saying that they were not joined in the suit in the way it was the state suing the federal government, and in that instance the Constitution provides that it can be the first and final court of instance, but if they had joined the CBN, then the Supreme Court would have lacked jurisdiction to listen to that, because they are the only ones who have the right to determine what is a legal tender and all of that. And then we move on to the arguments from the Attorney General's office, which sort of describe this largely as an order, not a judgment in some sense. And so in all of this, what exactly did that pronouncement meant for what currently exists, and where does all the deadlines stand with the Supreme Court's order?
Well, let me start by saying that generally, for the Nigerian, the only person that does not know what he's doing is the person that is given the job to do. Every other person knows more than the man that is in charge of their affairs. All of us as lawyers, all of a sudden will become judges. All of a sudden will become philosophers and all of that. But let me take my time, and I'll talk very slowly. Let me explain what is happening here. First, as to why you have the interim order. The courts use injunctions to ensure that matters that are urgent in nature are attended to by the orders. What am I saying? If the court is of the opinion that if they don't give an order immediately, the subject matter of the dispute would have been tampered with before the proceedings are concluded. Perhaps if the order is not made, then the entire essence of the proceedings would have been what? rendered, if I want to use what the lawyer call it, nugatory. That is made nonsense of, because at the end of the day you already have a fait accompli. The harm would have already been done. So in order to prevent that, you use the auspices of injunctions. And the injunctions are of three types. The one that is of what we call excessive urgency, I don't know if that's the word, but it's so urgent enough that you cannot wait for tomorrow. And those others, the court by themselves, even without any application, you could meet a judge who has power over that matter and ask for an injunction. He would give you. But our rules, in order not to abuse that power, our rules have streamlined the way and manner a litigant can procure those injunctions. First, if it is extremely urgent and the subject matter is one that is perishable or one that is extinguishable, if the order is not made, then the first way made is an interim order. Interim means in between, because as a matter of law, whatever dispute you have and you take to court, before the court can generally start hearing it, the other party must have been served with the process to give him or her the opportunity to respond. But usually the rules would give the other party, the rules already have dates. For example, they could say 14 days, 30 days for you to respond. In between the time you file and the expiration of that 30 days, the harm would have been done. You understand? So here, for an example, we have a deadline given, 10th of February. Obviously, if you have a dispute and you have an order, that urgency would what? Give credence to the granting of the interim injunction. The interim would be, it would act and operate in between this time that you come to see me ex parte, that is without the other party, and the time necessary for the other party to respond. So usually you have 48 hours to respond, generally, but they could give you more than that for you to respond. So in between that time, they could grant the order, and that is the order that was granted ex parte, without hearing from the defendant. And that's why it's short. Usually it can't be more than 7 days. If it goes beyond 7 days, it dies a natural death. Then there is the second injunction, which is interlocutory, which is between the time when the proceedings commence and the end of the proceedings. In between that, to say, for example, if we are fighting over a land, one person could ask for interlocutory injunction to say, between now and the conclusion of this case, let nobody enter the land. The court can grant that injunction to say, as from today, right up to the time when the case is determined, nobody should go into the land. So that is interlocutory, that is in between the proceedings. Then you have the one which is perpetual, which is after the case. If you win, for an example, if somebody is trespassing over your land, an order will be made to say, never would you do that again, either by yourself or your agent or previous, or anybody acting on your own behalf should never enter that land again. That is the perpetual. You understand? Yeah. So here, this is what we have. Then you see so much commentaries all of them talking about, oh, why the case shouldn't have gone to the Supreme Court, and why the central bank should have been joined as a party. Yes, the law says if a case cannot be determined without a person, that person is a necessary party. And therefore, he has to be joined in order not to have multiplicity of cases. If we are fighting over this land, and there's another party who says who lay claims
to the land,
he is a necessary party, because if we finish our fight and he is not there, then that means we have to institute another case. You understand? In this case, the thoughts are this. They said, oh, we are talking about the activities of central bank. And you now go to the court without the central bank, meaning that you want the case to be determined without hearing the central bank. And therefore, that failure to join central bank could be fatal to your case, because if the Supreme Court determines that the central bank is what? A necessary party, then he must join it. You understand?
Yeah.
But if you now join the central bank, then it now becomes another matter altogether, because what? The Supreme Court only has original jurisdiction over disputes between state against state and state against the federal government. You understand?
Yes.
So if you now bring a non-state party into the dispute, then it has to go to the Federal High Court.
And then come up.
And come up through the wrongs.
Yes.
But there is an aspect here which I have looked at, which very many people have ignored. And if you allow me, let me read section 20, subsection 3 of the Central Bank Act of 2007. This is what it says. Notwithstanding subsection 1 and 2 of this section, the bank shall have power, if directed to do so by the president, and after giving reasonable notice in that behalf, to call in any of its notes or coins on payment of the face value. What that one means, unlike all the other duties and functions and powers of
the
CBN, this one, it only and can only act on the directive of Mr. President. In which case, it can only be what? An agent of the president. If indeed, assuming
that's right,
the Supreme Court makes that finding that because of this provision and because the initiative has to come from Mr. President,
which is the executive,
and you are only acting on that initiative and pursuant to his own directive, then the buck will stop on who?
The president.
The president. And therefore, we already know who is what? Paying the piper. Meaning that we know what? The principal. So the law says, if you know the principal, and you know the agent would what? Bear no liability. Because what? He's a puppet. The person who bears the liability is what? The principal. In that case, you don't need to have any issues with what? The agent, the puppet.
So by implication,
you deal with what? The principal.
So by
so my thought and my guess is that that is the reason, and that is the case these people are going to make. They are going to say, oh, you are the initiator. This policy is yours. And for convenience, because of what? The nearness to the regular and everyday activities and powers of the central bank. That is why the central bank is given that role. So unlike the issue of what? The printing of notes and the minting of coins that are what? Prescribed in section 18 and 19, this one is for Mr. President. It's Mr. President's what? Initiative and directive. And Mr. President has owned up to it. He has told you that that is his own initiative for what? He gave two reasons. One, to fight bandits, and two, to prevent people from buying votes. And that is why you see Emefiele could what? Charter a plane to go to to Daura and ask Mr. President to say, people are asking for extension. What do I do? Do I give it? You understand? So that is the thinking, my thoughts, and my guess of the plaintiffs in this one.
So drawing from your argument, it is clear that the central bank cannot ignore the position of the Supreme Court with regards to the pronouncement around the deadline.
That would be larceny. When I hear people talk about it, I shudder. You cannot. That would make nonsense of the entire essence of the legal system. You cannot say, oh, I am not a party, and therefore I ignore the order of the Supreme Court. In any case, I would think that my brother, the Attorney General, would know the consequences of disobedience of that order, because until you obey that order, you will not be heard. So when you go there with your own this one, they're going to ask you, did you obey this order? You did not. If you are coming to equity, you must come with clean hands. You cannot, after that affront, you come. No.
So basically, you cannot choose what to obey and what not to obey.
It shouldn't.
Where would you situate this objection by the Attorney General? Is it to the same Supreme Court asking it to...
No, that's what it is. It can only be at the Supreme Court, no other place.
Would this now be saying disregard what you had initially pronounced?
No, it is not... They are not going to say disregard it. That order already stays. You know, once that order is made, until you set it aside, you cannot say no. What they are only going to... Because they are going to contest the application for the interlocutory injunction. That is an application pending before the court for an interlocutory injunction. So they are going to contest it. And part of the contest is challenging the jurisdiction of the Supreme Court. My thought, I read briefly there, I don't get the hang of it, to say, I think whether the parties were, there is some form of a misnomer or whatever it is, to me that is not it. But I think the thinking is that, like the general belief out there, is a central bank policy. Central bank is an agency that is independent of the federal government, and therefore you cannot, on the basis of its own activities and powers and whatever it has done, pin it on the president or the federation. That could be the argument.
So basically now, I just want to ask now,
yes,
from a layman's perspective.
Yes.
The old NAIRA notes continue to be legal tender until the Supreme Court says otherwise.
That's what I think. Okay. That's the way it should be. And in any case, the act in itself says so, to say, yes, the old NAIRA notes can cease after the time you've given to be legal tender. But you are bound to redeem it if I take it to you.
With valid reasons why you couldn't show up.
Yeah, well, you are bound to. You understand? And mind you, the act, and this is somewhere outside the law now, this is where you can make your own conclusion. The act speaks to reasonable time. And a reasonable time It's contextual.
That's right.
It's within the context.
Interesting.
What is there so urgent that more or less promote that fixation for the 3 months? You are talking about a society that will have 60% of the population are not part of the banking system.
Interesting arguments there from Senior Advocate of Nigeria. He has provided very fantastic illuminations around the pronouncement of the Supreme Court and the various legal perspectives that we have seen fly around of whether or not the Supreme Court has got jurisdiction and what we are likely to see after February 10th. I hope that we have provided you useful information to guide your actions going forward. I want to thank you, the learned Sikh, for finding time to be here, even at very short notice.
Thank you very much.
And I hope that we will continue to have you in the studios, continue to help Nigeria make sense of pronouncement from the sacred chambers. This is where we draw the curtain on today's production. This is the much time would allow us to bring to your living room this morning. I hope you will find us worthy and useful of the free access you provided to your living room. I am Sunday Michael Ogu. Please look up our social media handle, Instagram, YouTube, Facebook, if you had missed out on any of this important conversation today, to catch up and continue to stay tuned to Daybreak on Trust Television.
All right, it's been an amazing ride on Daybreak today. Why don't we do it all again tomorrow? I am Ibrahim Yusuf.